So, is that Mr. Easton? Yeah, it is.
Ellie, did you put your appearance on already? Chrissy,
Hours ago. No, go ahead.
Mr. Braswell signing on, by the way. That's why I just got off the phone.
This docket moves fast, but don't mistake speed for simplicity. What you're watching is a rapid-fire criminal calendar where every adjournment, bond decision, and exam date carries serious consequences. Behind these quick exchanges are people sitting in custody, waiting on DNA results, competency evaluations, or plea negotiations that could change their lives. Judge Simpson is juggling pressure from all sides. Defense attorneys pushing for time, prosecutors balancing readiness, and defendants whose freedom depends on paperwork actually getting done. Stay sharp here, because the drama isn't loud, it's procedural, and that's where cases are won or lost.
Your Honor, Chris Easton appearing on behalf of Jonathan Coleman. Mr. Coleman, would you state your name for the record?
Jonathan Coleman, Your Honor.
Thank you. Your Honor, we're going to set this for a preliminary exam. I believe Ms. Senda said, did you say the 30th or the 23rd?
30th.
I'm sorry.
Yeah, we're looking for the 30th potentially.
For an exam date?
So we'll be out. I don't know.
If that would be allowed, Your Honor.
You're pushing it, Easton.
I know.
All right. All right. Is all discovery complete?
Yes.
And would the people have their witnesses, the 30th, like way at the end of the month?
We'll do our best, Jeremy.
All right. Preliminary examination in person will be set December 30th, 2025, 9 a.m.
Judge Washington.
before Judge Washington. Bond will continue. Thank you. Court calls the case
Thank you,
People
Your Honor.
versus Benjamin Spike.
No, he did not. He.
Torshell Feaster on behalf of my client. What's your name? Benjamin. Yes, Mr. Spike. On behalf of Mr. Spike, please take the name for the record, sir.
Benjamin Spike. All right.
Thank you, Judge. I did meet with Mr. Spike yesterday and speak to him in custody. I also reached out to Mr. Childers. I believe we're still trying to get this matter resolved. I'd be asking for a brief adjournment.
That objection, probable cause conference will be adjourned December 18th, 2025, 9 a.m.
Thank you.
Bond continue.
Morning, Your Honor. Michael Vincent on behalf of Mr. Couch. State your name.
Harold Couch, Jr. Thank you, sir. You're seeking an adjournment?
Yes, Your Honor.
Well, you're asking about DNA testing. I don't know how fast that's gonna.
Your Honor, the testing is supposed to already be underway. We just haven't gotten the results back yet. APA Kennedy did send an email asking on November 18th for an update. We haven't heard back from that.
All right, so looking for an update by the 18th?
No, I'm sorry. We sent the email on November 18th, so
Okay,
I'm not sure exactly
where we are.
So,
He's out of custody, so let's do this. Will the 23rd work for Mr. Vincent? It will. And then he can get on a sleigh, drop all the toys.
That's the next day, Your Honor.
What? That's the next day?
Next day.
Oh, okay. All right. Probable cause conference will be adjourned December 23rd, 2025. That's 9 a.m. All right. Thank you. Bond continue. Court does call the case People versus Andrew Patton.
Yes, felt this for the people. Ready, Your Honor?
Good morning, Your Honor. Charlotte Stefan on behalf of Mr. Patton.
Your name, sir? Andrew Spencer Patton. Thank you. Seeking an address.
Yes, Your Honor, we're seeking an adjournment for two reasons. One, I have received discovery. However, some of the videos I think I'm missing. But also, I've talked with Mr. Childers and we're trying to reach a resolution of this matter. I did, however, also want to address bond, Your Honor.
Probable cause conference will be adjourned December 18th, 2025, 9 a.m. As to bond.
Yes, Judge, I understand that the last court date, which is preceded my representation, that the bond was revoked, I think, and that it was due in large part to my client not being able to afford testing and not understanding that he should appear for testing even if he can't afford it. He certainly understands the policies a lot better now and assures me that if Your Honor releases him, he will appear for all of his testing.
Any response from the people? You think you can understand that you've got to get over to testing?
Yes, sir. Lack of communication on my part, but
Pardon?
there's lack of communication on my part to the corrections officer.
I'll grant the bond modification and reinstate previous bond
Thank you very much, Your Honor.
with all of its conditions. So we'll be signing a new order to that respect. All right.
What's bond?
He's reinstating it how it was.
So you got to make sure when you get out, you report over to community corrections
Yes, sir.
to do the intake.
Yes, sir.
If you don't, you know what's going to happen.
Yes, sir.
All right. Thank you.
Thank you, Your Honor.
Trustee Step appearing on behalf and with Courtney Jones. Ms. Jones, did you state your name for the record?
Courtney Jones.
Your Honor, we are hopefully close to coming to some resolution. So I'm asking the court for another adjournment so that counsel and I can continue those plea discussions.
But we have to fit this into your schedule.
If it's more, yes.
Yes.
I would like to say,
Really, no-
Mr. Childers, I'm sure has an incredible schedule also. So.
I have, well, if you're close, I mean, I have the 18th, but I don't know. When you set the exam, you weren't available.
I can do the 18th. I don't know if that gives us enough time to,
I
Whatever you
have
want.
the 18th and the 23rd that I could do for a pre-season.
okay, 18th, Your Honor.
Probable cause conference will be adjourned December 18th, 2025, 9 a.m. Bond continued. Now that I had to do that for Mr. Easthope, everybody else is going to be asking, and I'm going to have to say no. He took every I had today.
So, Your Honor, can I ask you one question?
Oh, boy.
I actually have 2 hearings in the morning. Usually those cases get moved to the afternoon. Is that likely? Because it's not a custody case? All right, I'm not going to ask anymore.
No.
I'll just
what
set it
was
at
that?
9 a.m.
I didn't hear you.
Never mind. We'll see you.
Okay, you understand.
We'll see
You
you.
and Mr. Mack. I'm going to set it at 9. The person you need to talk to just entered the courtroom.
I was hoping everybody heard it.
Okay.
Thank you.
So
We'll get it. I'll get it.
on the 18th, you heard him. Were you as irritated as me?
He said he wants to come to the afternoon.
Oh, okay. All right. Very good. We're good. All right.
Thank you.
Thank you, ma'am. Court has called the case of people say to Michigan versus Antoine Pitts. For just, and you know what? I'm gonna call your friend back.
But I, Goldstein, appearing on behalf of the defendant.
Antoine Pitts.
Your Honor, I'm not counsel of record at this moment. I was just retained on this matter. I will get a substitution of the court, but I'm not sure if I'm substituting for Mr. Bernstein or for the public defender's office.
We have public defender withdrew. Mr. Bernstein was assigned. and
Has he filed an appearance?
Pardon?
Has he filed an appearance?
He has not filed an appearance, but I signed the order.
Okay, so I have to get a substitution. All right, that's fine. All right, Your Honor, in this matter, we are prepared to set this matter for an exam. So the record is clear. I do have the written police report. There are videos, but I'm going to waive those videos for the purpose of exam. Mr. Childers indicated that he would get them to me as quickly as he could, but I'm prepared to go forward anyway.
All right, and you would the people have their witnesses available the 16th?
That's fine.
Okay. The preliminary examination in person will be set December 16th, 2025, 9 a.m. That is before Judge Moore.
Judge Moore, thank you, Your Honor.
Yes. Bond will continue. Court does call the case People versus Shaquille O'Neal Tubbs. That is false.
Your Honor, Alexis Plea, appearing with and on behalf of Mr. Tubbs, who is present on Zoom. Mr. Tubbs, could you say your name? In Your Honor, we're requesting an adjournment. I did submit some orders for competency examination on these
Got
two
it.
files.
You're actually looking for forensic evaluation of competence.
Yes.
I will order a forensic evaluation and I'll set a competency hearing for March 5th.
And for the record, he has been opined incompetent or restorable in his other cases, so we'll see what happens here.
All right. March 5th, 2026, 9 a.m. Bond will continue. Court does call the case of the People versus Krista. Is it Boucher? Boucher? Yeah, they're writing on the file, so I have no idea.
Yeah, good morning.
Good morning, sir.
I'm Piotrowski on behalf of Ms. Boucher, who's approaching. Say your name, please.
Christina Boucher.
What are we doing?
You'd ask for an exam, Your Honor. I believe we've been told the 16th of December.
Well, depends on what I feel like. You have all of the discovery.
Yes, we're ready to proceed.
And I'm sorry. People have their witnesses available the 16th.
We'll do our best, Joe.
Preliminary examination will be set December 16th, 2025, 9 a.m. That is before Judge Freshour. Bond will continue.
Thank you. Would that be in this building or?
No, it's in this building. Court does call the case People versus Jason Smith.
And it's end up, people.
Good morning, Your Honor. Christina Sachs on behalf of Mr. Smith. Mr. Smith, please state your name for the court.
Good morning, Your Honor. Jason Smith.
Thank you. All right. You're requesting an adjournment?
Yes, Your Honor.
Okay. I see the reasoning. Is 2 weeks going to be enough or
Could I ask for based on Sergeant's
for 4 weeks?
response?
You have a problem? People have an objection to that? 4 weeks out is what well, we get into some weird holiday schedule, December 30th. All right. That'd be enough time.
I didn't hear the date.
December 30th.
Yes, it should be. Thank you.
Probable cause conference will be adjourned December 30th, 2025. Continue.
Happy holidays, Your Honor.
And to you, sir.
Morning, Your Honor. Michael Vincent on behalf of Tracy Atkins.
Your name?
Casey Atkins.
All right. My understanding, I have before me a plea form that indicates that she is going to plead no contest to the charge of false report of a misdemeanor.
Part of the plea bargain is that no upfront jail. Is that correct?
Well, that doesn't say anything on this form about that.
I didn't add it to the form. I don't have an issue with that, Your Honor. I didn't add it to the form. That is correct. They offer us plea to an out of count to false report of a misdemeanor, which is itself a misdemeanor. I believe it's the 93 day, and dismiss count one, which is the felony false report of a felony.
Yeah, that's all I have. I'll indicate that the two of you are agreeing to that. haven't looked at everything, so, well, I've seen the report, but I'll indicate on the form that you're agreeing to a sentence agreement of that amount, or that, with that factored in of no upfront jail.
I have explained to my client that does not mean that if she does something while she's on probation, jail is a possibility.
All right, may I have her sworn?
This is a critical courtroom moment. Bond wasn't revoked because of new criminal conduct. It was revoked over mistesting tied to confusion and lack of communication. That matters. Judges care deeply about why conditions are violated. Here, once the court hears that the defendant misunderstood testing requirements and now understands them clearly, the judge reinstates Bond, but with firm warnings. This isn't leniency, it's conditional trust. The court is saying, I'll give you another chance, but if you fail to report, custody is automatic. So ask yourself, should confusion ever cost someone their freedom, or does responsibility always land on the defendant?
Raise your right hand. You solemnly swear the court the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Casey K. Atkins.
The reason for no contest, Your Honor, is that civil liability.
Ma'am, it is this court's understanding that you're going to plead no contest to the charge of false report of a misdemeanor. That itself is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Understanding that, you still wish to plead guilty? Or plead no contest?
No contest, I will plead.
All right. And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you're pleading no contest. You're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
All right. Were you on probation at the time of this
Yes, Your
offense?
Honor.
I do have to advise you that that could be a violation of your probation.
Yes, Your
Understand
Honor.
that? You understand that if it is considered a violation of probation, that other court could, or courts could sentence you to the maximum allowable under those other the other charge or charges. You understand that?
Yes, Your Honor.
All right. And you still wish to plead no contest to this charge?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
I am, Your Honor.
and of your own free will?
I am, Your Honor.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 2507111. Any objection to the court having reviewed that report?
No, Your Honor.
Bless you.
Wow. What's that? Wow. I mean, bless you. Scary, like shockwaves. Anyway, ma'am, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. Do you understand that?
I completely understand that, Your Honor.
All right. And is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, the no jail is on the record, nothing else, Your Honor.
All right. And have I complied with the court ruling would be proper to
Yes.
accept this defendant's plea?
Satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
January 7th at 9 a.m.
January 7th?
Yeah.
For sentencing?
January 14th.
It's not the 7th. January 14th, 2026, 9 a.m. That's before me. Bond will continue. Thank you. You're welcome. You might want to stop down at probation on your way out. They'll be on your left-hand side.
Okay, thank you.
Thank you. Court calls the case, People versus Jeffrey. Oh, boy. Yeah, I found out things about her today. Yeah. I'll let her go, though. Go ahead.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon. Mr.
Bluhinger,
Bruninger, can you please say your name for the record?
Jeff Bluhinger.
Oh,
You didn't give me permission yet, right?
I did not give you permission, but you tend, given what I now know about you, that explains why you didn't wait. You just went right ahead.
Sorry.
But now even despite what I found out, permission to practice is granted.
Thank you. Thank you. Your Honor, I'm requesting an adjournment on behalf of my client
Any objection?
for 2 weeks, please.
What?
For 2 weeks.
Now she's gonna tell me what I'm. God's conference will be adjourned December 18th, 2000.
This hearing showcases the hidden reality of criminal court. Most cases don't explode in dramatic verdicts. They grind through scheduling, discovery, mental health evaluations, and plea negotiations. Judge Simpson enforces structure while allowing flexibility where fairness demands it. Bonds are reinstated, exams are set, pleas are carefully reviewed, and competency is taken seriously. The broader takeaway is clear: the justice system runs on procedure. And when those procedures fail or stall, real lives hang in the balance. If you found this courtroom breakdown as revealing as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.